Well, good morning, everyone. My name is Hillary Haynes from the Greater Bakersfield Chamber, and I'm your host for this morning's Labor Law and HR webinar sponsored by Young Wooldridge. I'm happy you could join us today as we hear from Attorney Jerry Pearson give us an update on how COVID-19 has changed the employment law landscape. And Jerry will also cover new legislation for 2021. That's so weird to say. Before we get started, I want to go over some Zoom etiquette to make this next hour and a half run as smoothly as possible. We have everyone muted to help eliminate any background noise. So if you have questions for Jerry, please use the Q&A or the chat boxes below your screen. They're on the bottom of your screen. We prefer to use the Q&A for questions and then obviously the chat for comments. This will notify Jerry and myself that someone has a question for us to answer. And then I'm going to go ahead and introduce Jerry, who is the managing partner at Young Wooldridge and leads the firm's business department. Jerry represents management in labor and employment issues and ensures his clients stay in compliance with state and federal labor laws. He has successfully defended employers in wage and hour matters, as well as cases alleging harassment, discrimination, wrongful termination, and other labor-related issues before the California State Superior Court, the California Court of Appeals, United States District Court, California Labor Commissioner, and the Department of Fair Employment and Housing. Jerry is a past president of the Kern County Society for Human Resource Management's Board of Directors. All right, Jerry, it's all yours.
All right, good morning. Can you hear me, Hillary?
Yes.
Okay, I'm assuming everybody else can hear me as well then. Good Wednesday morning to everybody. As Hillary mentioned, what we're going to talk about today is kind of a potpourri of things. This is not our end of year update. So what I'm going to do is talk about some key legislation and updates that have been signed and have been put in place by the legislature or are going to be put in place by the legislature in January. But this is not going to be the full-blown legislative update that we'll present to you in January, where we will cover all of the new employment laws that you folks should be aware of and all of the important case law that has happened this past year. But what I wanted to do is talk, as Hillary mentioned, is talk about we can't get away from it, this whole COVID thing. I think we're sick of talking about it, and yet we still have to because it does impact our workplaces and our workforce. And as HR professionals, we have to deal with it on an ongoing basis. So we definitely have to talk about it. So I'm going to talk about how it's affecting us, and I'm going to talk about some cases that have been filed not only in California, but across the United States, specifically related to COVID and workplace cases. And then I'm going to talk about some employment-related bills that have been passed and some that are in effect already in 2020 and that were put in place immediately, and some bills that we need to talk about coming on January 1. So as Hillary mentioned, those of you that have heard me speak before, I love to take questions as we go along. I loved it when folks would raise their hand and stop me, and we would talk about what's impacting your workplace. I can't see you raise your hand. You're welcome to do that, but put in your question by chat, and Hillary will relay those to me. We'll deal with them as we go along here. This presentation may not take the full 90 minutes. It's going to be dependent upon how much back and forth we have with questions. So if you have questions, please don't sit on your hands. Feel free to raise those, and we'll take them as we go along. So we're going to start on page 4 of our presentation, which talks about legislative updates. Well, yeah, go to page 4. But before I start with the legislative updates, let me just talk about in my practice how I see COVID impacting, and is it impacting, and how. And yes, it is, as I'm sure it's impacting all of you folks in your daily workplaces. And getting phone calls, getting emails, and the way I'm seeing it's impacting my practice and how I see it impacting my clients is dealing with the same issues we've always dealt with in the employment arena, such as leaves of absences, terminations, layoffs, wage and hour questions, paying overtime, reimbursing employee expenses. But we have this new element that's involved in every one of those issues, and that is the pandemic and COVID, right? So if you're talking about termination, if you're talking about layoffs, you have this, I always have this checklist I refer to, this mental checklist about protected categories and protected activity. And now we have COVID related to that. When we're talking about reimbursement of employee expenses and payment of wages, well, now we have this element of, have your employees been working remotely? And if they're working remotely, have we been paying them properly? If they're hourly employees, have they been clocking in properly? Chances are probably not. Do we have any employee expenses to deal with, such as Wi-Fi, computers, employee materials such as paper, pens, phones, etc. All those things to deal with. So all the same issues we've always dealt with, but now there's a new layer to it, and it's this COVID thing. And specifically related to COVID, I still get a lot of questions about the FFCRA and sick leave. And is this sick leave that this employee wants to take or is taking, is that supposed to be the 80 hours of COVID sick leave, or can I use that on regular sick leave? Or if they've exhausted the 88 hours of sick leave, what do I do now? And those sorts of things that are directly related to specifically COVID. So yeah, it's getting questions about it every day. I'm sure you're dealing with it every day. I can't keep up with what tier we're on here in Kern County. I got to look in the paper every day to see if we're in tier red or tier purple or tier orange. Can I go to the restaurant and eat inside? If not, can I at least eat outside? Is movie theater open? All these things. And so all of those folks are my clients as well. And so on a daily basis, I'm fielding questions from clients about can they bring your employees back today? If they go back into the former tier, what do they do with their employees? Do the employees go back on leave? Do they have to pay them? So it's this element that we've never dealt with before that I think we all thought was going to be handled within a relatively short period of time. And I think now we're realizing it's going to go on for quite some time. Some of you may have operations in more than one county, right? If you have operations that are in more than Kern County, and obviously I have clients that work throughout the state, we're dealing with these levels and tiers. I might have a client that's in tier red in Kern County, and they're in tier orange in Orange County, and in tier purple in San Francisco. And so it's jumping through hoops just to keep up with all these different tiers throughout the state. So it can really cause a lot of stress to employers and HR folks trying to keep up with all these different rules and tiers and what you can do and can't do in different counties throughout the state. So it's quite a new era we're living in. I have heard many attorneys statewide say that, yeah, we're in a pandemic now, and we're just on the cusp of a tidal wave of lawsuits that are going to happen, throughout they're predicting 2 years. I don't know if that's going to be the case or not. We'll talk in the second half of our presentation today about those lawsuits that have been filed in California and throughout the United States since COVID has occurred and since the pandemic has happened. What types of lawsuits those are, what types of lawsuits we're seeing, specifically related to employment, what you folks should be on the lookout for in terms of those lawsuits, what types of issues are being raised in those lawsuits. So we'll see. We're all in it together, and we're all going to see. So with that, let's dig in on page 4. The first page you're going to see are bills that are already in place. These are bills that were passed by the legislature during the second half of 2000. And because they are what's called emergency legislation, they became effective immediately. So be aware that as we talk about these bills on page 4, these are already in effect. So if you haven't been made aware of these or dealt with these at your work site, be aware that these are already in place and you need to deal with these as you go back to work today. AB 1867. This is the supplemental paid sick leave and small employer family leave mediation. Most of you, if you have less than 500 employees, you were probably aware that. I see a question from Dr. Webb. Yeah, the slides, they should be made available to you. I'll just short circuit that one, Hillary, since I saw it. It's an easy question. The slides should have been made available to you prior to the presentation. And if not, if you don't have it, absolutely, they will be made available to you after the presentation. But yes, they are available to you now. And if not, they absolutely will be made available to everyone after the presentation. Hillary, did you have anything to add on that?
No, I sent them out. They were attached in the email that went out this morning. Oh, she just said, guess I should read my full emails. I tried because I think I usually get a couple of attendees always ask if they could have them ahead of time to take notes. So right. I hope this helps everyone.
Right. So we do try to do that. So in any event, there was the CFRA was passed, I believe, April of this year, Family's First Coronavirus Relief Act, which put into place extended benefits for employers with less than 500 employees. This included the 80 hours of specific COVID-related sick leave and some additional leave benefits under the FMLA. Well, this AB 1867 adds not additional FMLA protections, but it adds only the specific additional COVID-related sick leave. This is 80 hours of additional sick leave to all employers who have 500 or more employees. And this did affect some of my clients who have 500 or more employees who were not impacted earlier in the year by the FFCRA. They are impacted by this bill. It puts into effect new Labor Code Section 248.1. If you want to go look that up, 248.1. But it does show that you have your employees now have 80 hours of additional sick leave specifically related to COVID symptoms, treatment, etc. Okay. The second bill is a SB Senate Bill 1159. This is a workers' compensation a rebuttable presumption. If you have an employee, and I'm not a workers' compensation expert. We had a presentation we did a couple of months back. I believe it was for the chamber with myself and a workers' compensation attorney by the name of John Robinson, who's a local attorney who is a certified specialist in workers' compensation law. And at that time, John spoke on the presumption that was put into place earlier in the year by Governor Newsom. This bill extends that presumption, and in terms of length of time, because that bill sunset on July 31 of 2020. But there is now an extended bill for a rebuttable presumption for employees that allege contracting COVID at the work site. So there's now a presumption that can be rebutted by the employer, but presumptions in workers' compensation cases are difficult for employers to overcome. At any rate, this bill puts that into effect. It also now requires employers to immediately contact their workers' compensation insurance carriers as soon as that employee raises an allegation of COVID-19 that is contracted in the workplace. Third bill is AB 2043. This bill is related to Cal OSHA, and it requires Cal OSHA to provide COVID awareness materials to California employees in both English and Spanish. The fourth bill is AB 1512. This one harkens back to a case that came out a couple of years ago. You might recall it was a rather important case in California. California Supreme Court case that stated that security officers had to be relieved of all duty during their rest breaks, kind of sent shudders through the California employment community. This bill kind of walks that back a little bit and says that certain security officers, if they are, let me read it right here, if they are registered under the Private Security Services Act. So if you are a private security company, and you have security officers that are registered through Private Security Services Act, those security guards and security personnel now are allowed to remain on duty and have remain on call, and may have cell phones and pagers on them while they take their rest breaks. So it walks back that prior case that from the Supreme Court. It is important to note, however, that if you have security personnel that are subject to this bill and they are called back to duty during that rest break, they must be allowed to restart their 10-minute rest break and have a full 10-minute rest break during their shift. So if you have an employee that is subject to this and they are interrupted during their rest break, they must be allowed to restart their 10-minute rest break and enjoy their full 10-minute rest break. Otherwise, they're still going to be owed that 1-hour penalty for not taking a rest break. You have any questions so far?
It doesn't look like it, Jerry. Not yet.
Okay. I'm moving on then. AB 2479 also deals with rest breaks with in regard to certain petroleum workers. It provides an exemption from past January 1, 21, which was previously in effect. It extends that exemption through January 1, 2026. The exemption currently exists in Labor Code Section 226.75. And an exemption applies to rest periods for specified employees who hold safety-sensitive positions at petroleum facilities. And that exemption applies to the extent that they must carry and monitor communication devices and respond to emergencies, or remain on the employer's premises to monitor the premises and respond to emergencies. So those employees may continue to remain on duty during their 10-minute rest periods, but it's only for those specific employees in those conditions. AB 2257. I don't know if you guys remember now, but before all this pandemic happened, we were all up in arms about AB5. That seems like forever ago, but this was the independent contractor bill that kind of wiped out, or was trying to wipe out, the entire cottage industry of independent contractors, and was trying to make everybody employees, but with some rare and limited exceptions. AB 2257 has gone into effect, and it revises some provisions in AB5. It has provided some clarification to some of the prior exemptions that existed. You might recall that there were some limited and specific exemptions to AB5, not all of them that we were hoping for, but provided some exemptions. There are some questions regarding some of those exemptions, and this bill tries to clarify some of those. It does provide some additional specific exemptions, again, not the ones we were really hoping for. I know that the trucking industry in particular is still fighting for an exemption. It is not included in this bill. The exemptions that were include person supervised underwriting inspection, home inspections, people of those industries, but some very limited exemptions were included in AB5. I'm sorry, to AB5 in this bill. I'm sure most of you are aware of the ballot initiative. I believe it's 22. I should remember it because I've already voted, but I believe it's 22 that could make some changes to the existing law in regard to independent contractors. So I'm sure we'll be talking about this again come January in our beginning of the year legal update. Hopefully at that time we'll know what the upshot of the ballot initiative was, and what, if any, if that passes, impact that may have on AB5 and our independent contractors versus employee discussion. Finally, the last assembly bill that has already gone into effect, I don't think it's going to affect many folks on our webinar today, but it involves the entertainment industry and sexual harassment training for minors. AB 3175 and now requires that if minors who are employed in the entertainment industry, they have to undergo sexual harassment training. That was already in effect, but this assembly bill requires that they be accompanied by a parent or an adult guardian in that sexual harassment training, and that adult guardian sign and acknowledge the fact that they attended the training and received the materials. Okay. Any questions about the bills that are already in effect? Okay. So let's go on to page 5 of our handout. Again, these are not all the bills, of course, that are going to come into effect January 1, but just a handful that I've selected that I think are important and we should talk about today. SB 973, this talks about the employer's annual report on paid data. This is just a state bill that kind of follows the federal requirement that employers already have. This requires private employers with 100 or more employees that must already file the federal annual employer information report, which is known as EEO1, to also submit on or before March 31, 2021, and each year thereafter, a paid data report to the DFEH, the state agency, that states the number of employees by race, ethnicity, and sex in the following categories: all levels of officials and managers, professionals, technicians, sales workers, administrative support workers, craft workers, operatives, laborers, helpers, and service workers. So just more evidence of the state trying to reach its tentacles into your offices there and find out everything that they want and need to know about your employees. So I'm not sure all the information that you currently have to put on the federal EEO1 report, but you pretty much got to put everything now on this state DFEH report. Again, that's SB 973. Settlement agreements, AB 2143, settlement agreements and no hire provisions. You may recall, I know that I've talked about this over the last year. When you enter into a settlement and release agreement with an employee or a former employee, releasing a lawsuit or a potential lawsuit and their claims against you as an employer, those of us who are defense attorneys, you know, we've always tried to include everything, including the kitchen sink, as the old saying goes, in these release agreements. And the California legislature is slowly eroding all those things that we can put in a release agreement. Confidentiality clauses are oftentimes not allowed in release agreements any longer, depending on what type of case it is. And one of the things that has been eliminated in the last year or 2 years are what are called no hire provisions. And that's a real bummer, because I always included that in my release agreements, right? I mean, when you settle with your former employee, you know, Johnny X, you don't want this guy coming back the next day and knocking on your door and filling out an application for that open position you have for a stock boy. And then he's alleging that you didn't hire him out of retaliation for his prior lawsuit against you or whatever. I mean, you just don't want to deal with this guy again. But the legislature a couple of years ago put forth this bill that said you can't include those any longer. And so AB 2143 is just a clarification of that. It prohibits no hire provisions in settlement agreements. It was AB 749 was enacted in 2019, exactly. And that prohibits no hire provisions in settlement agreements unless the employer has determined in good faith that the aggrieved person engaged in sexual harassment or sexual assault. So if you had an employee, let's say you have an allegation of sexual harassment, you do an investigation and you determine in good faith that this employee committed sexual harassment, which is rare. I mean, employer is not going to, an employer is rarely going to determine in an investigation that an employee committed sexual harassment. You might find that some policies were violated, but it's rare that an employer is going to make a determination of harassment for various reasons. But unless you make such a finding, you couldn't include a no hire provision in this employee's release agreement. Well, this new bill, AB 2143, revises that prior law to require that the employee has filed the claim in good faith for the prohibition to apply. So in other words, you have to also find that the victim in this case had to file the claim of harassment in good faith. Long and short of it is you're not going to be able to include these no hire provisions. Okay. So except for very rare circumstances, you can talk to your own attorneys about this, but except for very, very rare circumstances, are you ever going to be able to include any more a no hire provision in a settlement and release agreement with an employee or former employee? What's the upshot if you do? If you do include a no hire provision, I can't tell you that the entire agreement would be withdrawn and found to be unenforceable, although it's possible. I don't know of a case yet that's been filed on that. Certainly that provision will be struck from the agreement if a former employee sued on that. But I think it's possible. I think it's certainly possible. It's not worth the risk to me to advise a client to put that in. It's certainly possible that an employee could bring a suit and say that entire release agreement should be found to be void and unenforceable. So at any rate, if you have settlement agreements laying around that you use as a form, that's why I always advise clients, don't use a former settlement agreement that we provided to you a year ago or 2 years ago and just whip it out again and have an employee sign it, because these things are changing all the time. Again, things you can no longer use, no hire provisions, probably a no confidentiality clause, and additional things that maybe were previously allowed and are no longer able to use. So go back and review your former settlement agreements and take these things out. AB 685, new mandated COVID reporting. AB 685 requires employers within, one business day. So don't give you very long, but you're required now within one business day of receiving notice of potential exposure to COVID-19 in the workplace to do the following things. 1, provide written notice to all employees, the employers of subcontracted employees, and exclusive representatives who were on the premises at the same work site. 2, provide all employees who may have been exposed and their exclusive representative, whoever that is, with information regarding COVID-19 related benefits, including but not limited to workers' compensation, COVID-19 related sick leave, company sick leave, state mandated leave, or supplemental sick leave. And 3, notify all employees, the employers of subcontracted employees, and the exclusive representative, I guess that's a union, now that I think about it, on the disinfection and safety plan of the employer, that the employer intends to implement. So obviously this deals mostly with construction industry, if you have all these different subcontractors and union representatives, but those are your requirements now. Again, that goes into effect January 1, so you've got a little time to put your plan into place here. But if you receive notice of potential exposure to COVID-19 in the workplace, that's now what you've got to do within one business day. AB 1947, DLSE complaints statute of limitations. This deals with complaints of retaliation that are handled at the DLSE. Previously, the statute of limitations for filing such complaints for an employee was 6 months. Now it's 1 year. So an extension of the statute of limitations there. SB 1383. This is the major one. This is the big one that I think we need to talk about. This is the big one that employers and HR professionals need to prepare themselves for. And this is the expansion of the California Family Rights Act. And so in California, we've been able to essentially mirror our CFRA, which is short slang for California Family Rights Act, CFRA, policies and leaves with FMLA, the federal FMLA. We've been able to mirror those by and large for years. And now that's no longer going to be the case as of January 1, because the California legislature has expanded who qualifies. Well, essentially they've expanded what employers are a qualified employer, a covered employer under CFRA. Long and short of it is, for years, any employer with 50 or more employees was considered a covered employer for purposes of FMLA and CFRA. That is still the case for FMLA, but no longer for CFRA. Now you are considered a covered employer under CFRA if you have 5 or more employees. So this is going to really introduce the world of CFRA to every employer in the state of California, with rare exception. All of you folks who have 50 or more employees, I can't say you don't have to worry about this, because there are some differences between CFRA and FMLA that now you're going to have to learn and deal with and massage the differences between FMLA and CFRA. So there's still a bit of learning that's going to be involved there. But for all employers who have less than 50 employees, they're going to be introduced to a whole new world of benefits and notices and rights and responsibilities and all sorts of things that they never had to deal with before. So it's going to be a brave new world and a scary new world. My firm, Young Wooldridge, for instance, we've always had just under 50 employees, and it wasn't for the purpose of staying under FMLA. It's just a matter of, that's where we were and where we are. So as of January 1, we have a whole new world of benefits that we have to deal with as a company, as a firm. So I encourage all of you who have less than 50 employees to take a crash course in CFRA, to get your policies up to date, to make sure that you have your notices ready, to make sure that you have your CFRA policies and leave of absence policies ready to go. By the way, hand in hand with this, the California Parental Leave Act goes away. That was something that we've had for the last couple of years that essentially provided baby bonding to all employers with 20 or more employees. That's going to be unnecessary now, and it really does go away, because that's going to be covered by CFRA. So employees will now be able to get their baby bonding leave under CFRA with 5 or more employees. So again, this is the big one. This is the one that employers need to be aware of and look out for, and make sure they're ready to be up and running with as of January 1. Any questions so far?
It looks like someone said, just to be clear, the settlement agreement does not allow for employers to include a no hire provision when an employee separates from the company, correct?
Right. Yeah. So going back to that, yes. So that is something we always used to include. So if you have, and when I say old, if you have a settlement agreement that dates back to 2018 and maybe 2019, if it wasn't updated, it may very well have a provision in there that says, the employee agrees that he or she will not apply for reemployment with the company. And that if they do apply for reemployment with the company has no legal right to consider their employment. And if they're hired, this settlement agreement provides a legal basis, legal cause to terminate that employment, or something to that effect. That's generally what those clauses said. Those used to be legal and valid and enforceable, and they no longer are. So I would recommend that you go back and review your old settlement agreements. They're fine prior to 2019. But if you're going to use, first of all, I don't recommend you use old settlement agreements and regurgitate them, because every case is different. Every factual pattern is different. So I never recommend clients do that. Always talk to your attorney and make sure that the current settlement agreement you're going to use for this employee and in this set of circumstances is good. Okay. But I know that sometimes employers don't listen to me and they want to save money and save time and whip out an old settlement agreement and just put the new names on there. Okay. I don't recommend you do that. But if you do, there are some things that were legal 2 years ago that aren't legal in agreements anymore. And the no rehire provision is one of them. Yes, the answer to your question is yes, you cannot have a no rehire provision in a settlement agreement any longer. Any other questions so far?
Yes.
Okay.
I think you may have answered this. So just for clarification on the supplemental California sick pay for employers over 500 employees, do the same tax credits apply, similar to the FFCRA pay for smaller employers?
That's a good question. I believe they do. I haven't looked at that specific question to be sure. But I believe the tax credits for sick leave provisions do. But to be certain, I would ask your accountant.
Okay. It looks like that's all the questions for now, Jerry.
That it for now? Okay. Okay. So that's it on the CFRA expansion. We will talk more about that obviously come January. But I think it's important to talk about today because where are we today? October, middle of October, October 20th, thereabouts. So you have 2 months to ramp up, get ready for that. Because you may have someone knocking on your door January 2nd saying, I want baby bonding leave. And they may be entitled, or not just baby bonding, who knows, leave to take care of a serious health condition, whatever could apply. And you need to be ready for that as of January 2nd. You need to have your notices ready. You need to have your leave policies ready and be up and running and ready for that as of January 2. So not in effect yet, but will be in effect January 1, 2021. AB 2992, victims protected time off. In California, we have had leaves of absences for victims of sexual assault and crime victims, domestic violence, stalking for some time now, depending on the size of the employer. And AB 2992 is amending Labor Code sections 230 and 230.1 to expand the prohibition of discrimination or retaliation against employees who take time off for those purposes to include other crimes or abuses that cause physical injury or that cause mental injury and a threat of physical injury, and a person whose immediate family member is deceased as the direct result of that crime. AB 2992 defines crime as a crime or public offense as set forth in section 13951 of the government code, and regardless of whether any person is arrested or prosecuted or convicted of committing the crime. So I don't know, we're gonna have to see how that one plays out, but it's a rather large expansion of those two labor code sections, which previously were fairly well defined as victims of, I guess well defined as victims of domestic violence, sexual assault, or stalking. So we've added some crimes to that. So be aware of that one. This is a good one. AB 1963 has added to the list of mandated reporters human resource employees. Congratulations. So this bill amends section 11165.7. I'll say that again. Section 11165.7 of the Penal Code to expand the list of mandated reporters to include human resource employees of a business of 5 or more employees that employs minors, as well as adults whose duties require direct contact with and supervision of minors, in the performance of the minor's duties in the workplace. Okay, so if you are an HR professional, or not even professional, a human resource employee, okay, who works in a business of 5 or more employees that employs minors or adults whose duties require direct contact with and supervision of minors, the performance of the minor's duties in the workplace, you are now a mandated reporter. Okay, so I would go back, if you fall under that, I would go back and look at that penal code section. Again, that's 11165.7, and read what those requirements are. Finally, SB 826 talks about the board of directors of publicly held corporations. You may recall a couple of years ago, I think it was 2 years ago, there was a bill passed that required boards of directors of publicly held corporations to have a minimum number of female directors on their boards. This bill now expands that to also include, let's see, that is now included to include one person from an underrepresented community on their board by the end of 2021, and 2 to 3 members of an underrepresented community, depending on the size of the board, by 2022. The bill defines an underrepresented community as an individual who identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identifies as gay, lesbian, bisexual, or transgender. Violations of this provision could subject the corporation to a fine of $100,000 for the violation and $300,000 for subsequent violations. So again, if you are a director of a publicly held corporation, I would pay particular attention to SB 826, which was passed in 2018, and SB 979, which is the new expansion of that. Any questions about the legislative bills that we've just discussed? And again, this is not the exhaustive list that we will discuss come January in the full-blown year-end legal update, but these are just the bills that I think are important for you to know about now, either because they have already gone into effect, or because I think you need some lead time to get ready for them, because they're effective January 1, and you don't want to get caught off guard come that day. Okay. All right. So moving on to case law on page 7. So what I've done here is this is actually a list of employment law cases that have been filed since the pandemic was declared, and these cases are employment cases that are directly related to COVID-19 related allegations. So I have before you just a list of the cases. I'm not going to discuss in detail the cases. First of all, none of these cases have been decided. Okay, so this is not like a case law update where I tell you this case has been filed, these are the allegations, this is the decision, and this is why this decision is important for you as an employer. Okay, that's not the intent of this list. The intent of this list is to discuss with you over the last, October, this pandemic was declared in March, so about 6 months. Over the last 6 months, how many specific employment law cases? This is not talk about cases that are personal injury cases or cases that are unrelated to employment law related allegations. These are only employment cases. It's intended to show you how many cases have been filed across the U.S. It's intended to tell you what types of employment causes of action have been filed, what types of cases have been filed in California. And the reason for that is, as an employer and as a defense attorney, it's important to know what kind of cases have been filed, what the allegations are, what plaintiff attorneys are looking at, what types of cases are they looking at filing, what cases have actually been made it to the courts, what causes of action, what allegations do we need to look out for as employers and as defense attorneys. What might be coming our way. So that's, and along those lines, I'm going to talk about what cases I've got two myself that are on my desk that are currently in litigation that I'm defending. One in Kern County, one in Fresno County. So I'm going to talk about those. And they're not too different than these cases that are on this list. So with that, let's dive in. And again, if you have questions, please stop, ask them, and we'll deal with those, okay? All right, page 7. Stevens versus Saginaw Products Corporation. This is a case in the federal courts out of state of Michigan, filed less than a month ago, September of 2020. And this alleges claims under the Family's First Coronavirus Response Act, FFCRA, for alleged failure to inform employees of their rights to paid leave and subsequent denial of paid leave. So again, know your rights, know your responsibilities as an employer. I still have clients calling me saying, believe it or not, what sick leave benefits are my employees entitled to under FFCRA? Does that apply to me? So there are lawsuits that have been filed under that exact issue, and not only one. Chowdhury versus Raja, Eastern District of New York. Again, filed 1 month ago, September 2020. This alleged failure to pay proper wages. You'll see that about 50% of these cases, I didn't count these, how many cases have been filed, but about 50% of them involve improper payment of wages or failure to pay wages and overtime. Calero versus Fanatics. I know Fanatics well. That Fanatics is that's an online website that sells like sports apparel, like team gear, Red Sox gear, Dodgers gear. I spend too much money on the Fanatics website. This was filed a month ago, September of 2020, alleging violation of the WARN Act. If you're not familiar with the WARN Act, it involves, depending on the size of the employer, depending on how many employees you might be laying off, the WARN Act requires, Hillary also says she loves the Fanatics website. Yeah. I spend too much time and money on the Fanatics website. But in any event, the WARN Act requires employers to send out notice to all impacted employees, and depending on the jurisdiction where you're going to do the layoffs, it requires the employer to send notice to either the city council or the board of supervisors, notifying them of the upcoming layoff. This is why sometimes when you read a newspaper, you'll see an article in there tipping, saying, company X has notified that next month there's going to be a layoff of 500 employees. And you might be wondering, well, how in the world does the Bakersfield, California know that, Fanatics is going to lay off 500 employees next week? Well, it's because they had to send a letter to the board of supervisors notifying them of the layoffs, and that becomes a public record, and the California got a hold of that letter. So in any event, Calero versus Fanatics. Calero alleges that Fanatics laid off a number of employees and did not properly follow, or maybe didn't at all follow, the WARN Act before they made those layoffs. Okay. Castelluccio versus Alfera International, filed just over a month ago, August of 2020, in the Eastern District for New York. Failure to pay wages and overtime. I don't know by just looking at these cases, but I suspect the reason why so many wage and hour cases have been filed in response to COVID is because of the remote work issue, and because you have employees that are working at a remote location from home or wherever, and they're working remotely, they're working on a computer, they're working on a laptop, whatever, and you've essentially lost, as an employee, you've lost control of these employees and when they're working and how they're working and where they're working, and are they clocking in, are they clocking out. Employees are going to allege, and I'm not saying they're alleging these things improperly. Let's face it, some are not. Some are being truthful and some are not being truthful, as with every employment situation. But they're going to allege that they're working more than they are. Some of them. They're going to allege that they're working when they're not clocked in. They're going to allege that my employer told me to only clock in certain times, but I had to get my work done. There's going to be allegations that the time records don't accurately reflect the time that these employees are working. So it's just a reflection of these times that we're in, that you're going to have allegations that employees are working off the clock time, or they're working remotely and the time records are just not accurate, screwed up, whatever. You're going to have allegations that employees are working from home and had to use their own personal computer, or use their own personal printer, or use their own personal yellow legal pads, or use their own personal home phone, or use their own personal internet connection. And so they weren't reimbursed for that. Or you're going to have allegations that the employer told them to purchase these things and use these things and told them they were going to reimburse them for this and didn't, or didn't properly reimburse them. There's just all sorts of issues that are coming up because we're in this situation where you have all these employees that are now working from home, working remotely. And it's because the employer doesn't have proper checks and balances in place to monitor employees from home. They weren't ready for this. Nobody was ready for this to happen in March. And even though maybe they've set up protocols now, it's gone on 6 months, and maybe we got comfortable with the setup we have with our employees at home, and now things are popping up and that we didn't expect. So I suspect this is why we're seeing a lot of wage and hour cases being filed in the face of COVID. Where was I? Harwell Payne versus Cudahy Place Senior Living, minimum wage and overtime. I also suspect we're seeing a lot of cases involving senior living facilities or at-home medical facilities. And that's a particular problem area, not only for contracting COVID, but also for these work-related cases for the same reason, because you're having employees that are, it's just a hotspot, not only a hotspot for catching COVID, so we're told, and so we're seeing, but also because you have folks that are working in situations where they're maybe not happy to be working around the clock in a area where they may be more likely to contract COVID. But you have these round the clock issues. You have multiple folks coming in and out of these facilities. So we're seeing a lot of cases filed out of these senior living facilities, group health facilities, at home health facilities, a lot of cases being filed out of these places. McBride versus DMI GMC Holdings, wages and overtime allegations. Gonzalez versus Colville Engineering Electrical. That is an FMLA and FFCRA retaliation claim. So you have some employees alleging that they apparently took FMLA and FCRA leave or benefits and were then retaliated against for doing so. Canis versus Smithfield Packaged Meats. That's another wages and overtime allegation. Woodward versus Van Kuren Services. This is an FFCRA retaliation claim. So you have employees, again, alleging they used or attempted to use FFCRA leave and were retaliated against. Saliba versus MedPace Inc. Filed in August of 2020 out of Ohio. This is an interesting allegation. This is age discrimination. A plaintiff in this case allegedly was terminated He alleges age discrimination and that the employer used the pandemic as a pretext for terminating him or her. So, in short, the employee was terminated. Employer says, we're letting you go due to a downturn in business because of the pandemic. Employee says, baloney, you're terminating me because of my age, and you're only telling me it's because of the pandemic. Jana Sivovich, whatever, versus Classica cruise operator out of Florida. That's a wage issue. Pacheco versus Yorkshire Building Services. FFCRA, failure to provide sick leave. Wrongful termination, post-COVID diagnosis. So a couple of things at play here, including the employee alleges that they had a COVID diagnosis and were wrongfully terminated thereafter. Okay, the rest of these things are not real exciting. Wages, overtime, OSHA, an ERISA violation, alleged ERISA violation. Let's move on to page 9. Mackey versus Coconut Joe's. I'll let you know this is not Bakersfield's Coconut Joe's. This is from some other state, South Carolina, I believe, in 2020. That's a wrongful termination claim. Connors versus American Medical Response. That's an overtime claim. Professional Staff Congress versus City University of New York. Wrongful layoff. The next one, Brent versus Amazon Fresh LLC. This is California. This is the first California case on our list here, rather than June of 2020. This is alleged failure to implement proper safety protocols. So you're going to see a number of these cases as well. So plaintiff here alleging that the employer failed to provide or failed to implement proper safety protocols in the workplace. So, if you've heard any of my presentations I've done specifically in regard to COVID over the last 6 months, one of the things that I keep talking about is you've got to put in place a protocol. You've got to put in place a plan. And and I'm not going to take credit for this, many attorneys were saying this, I was just one of them, saying that we suspected some of the lawsuits that were going to be filed was going to be you failed to adequately protect the employees in the workplace. You failed to adequately put in safety measures and safety protocols. And so the advice that I gave, and many other attorneys did as well, was, one way to defend these cases was to draft and put into place a written protocol of what measures you as an employer were going to put into place and follow it each day. Because, nobody had ever seen any of these cases before. At that point, now we're seeing some of them, but at that point, March, April, May, nobody had seen a COVID lawsuit actually be filed. So we were trying to anticipate what they would look like and how we would defend them. And so I thought, well, logically, one piece of evidence I would like to show as a defense attorney would be a manual, a written protocol that would show what steps my clients took to think this out and what the written protocol would be and how we followed it. And one of the simple examples I gave was, when you when you used to be able to, and maybe we can now, I don't know what tier we're on today. I haven't looked at the newspaper, but when you go into the restroom at a restaurant, right? And you would look on the back door, the back of the door of the restroom door, and it would usually say, this restroom was cleaned by Joe at 12:15 p.m., right? And so you could use that as evidence to say, well, in our protocol at 12:15, Joanne's going to come in and wipe down the counters of the conference room. And there's her initials. And at 1:15, Joanne's going to come in and wipe down the counters of the conference room. And also after every meeting that took place, you'd have the protocol would be that the receptionist or whoever was assigned to do that would come in and wipe down the table and the chairs and whatever was used. And we do that here in our office. I get sick of it, but I do it every time we use the copy machine in our assigned area. We got to get out the spray bottle and spray the buttons we pushed and the glass on the thing and all of that. But that's, the reason why you do that is twofold. One, to protect your coworkers and yourself, I guess. But then also, to use as evidence should somebody ever sue you, alleging, like Mr. Brent did against Amazon Fresh, the failure to put in place proper safety protocols. Here it is. So if I was the attorney for Amazon Fresh LLC, first thing I would do is whip out that written protocol showing, well, here's what we drafted. And this is based upon CDC guidelines or whatever was in place at the time we drafted it. And here's our checklist that's initialed every day by our employees of when we clean these things and what time it's done, and after every meeting and after every time the equipment is used, et cetera. And I don't know if that's going to be an adequate defense or not, because nobody's ever defended these cases. But I think at this point in time, that's about the best you can do. And hopefully every time Mr. Brent or Ms. Brent, whoever the plaintiff is, made a complaint about, hey, I don't have enough cleaners, there's not enough wipies, or there's not enough, we don't have face masks at the front desk, or I'm required to talk to customers closer than 6 feet, or whatever the allegations are, that there was an email response to that from Amazon Fresh managers saying, okay, we'll take, that's not in correlation with our protocol, we'll take care of that, and there was an adequate response. But those would be the way I would want to defend those types of cases. Hopefully that's what's done in this case, and hopefully at your workplace, that's what's something similar to that is what's being done, because I think that would be how you would try to defend these cases that are alleging failure to implement proper safety protocols. And there are a number of those cases that are, you will see on this list, that are making those allegations. Any questions?
Jerry, there is a question, and someone was wondering if you could share any lawsuits going on here locally. They said that employees talk, and this at times helps them see some different lawsuit trends.
Yeah. So I did mention that I was going to talk about a couple that I have. There are no lawsuits on this list. This is the latest list I have. But I do have a couple myself. And the reason mine are not on this list is twofold, but I'll tell you about mine. The first case I have is still at the DLSE level. So those cases will not be on this list. So that's the reason this first case I have is not on this list, but I'll tell you about it. And this case is out of Kern County employer. And it's an FFCRA retaliation allegation. And so, we're still in litigation with it at the DLSE level. And so it might go to Superior Court. This plaintiff might take it to Superior Court, but he hasn't yet. But the allegations in that case are the following. So long-term employee with the local Kern County employer, troublesome employee, checkered past, but not enough to terminate the fella. He was working, he had been disciplined over a couple of things, was possibly on the verge of being subject of stronger discipline, okay? But COVID happens. This employer does not shut down. It's an essential employer. They kept working. He keeps working, but he requests leave to take care of his stepdaughter under FFCRA. Her school shuts down. We think that's fishy. But we grant the leave. Okay, we grant the leave under FMLA, expanded FFCRA leave. We give him his leave. Okay. While he's on leave, we discover some additional significant performance issues going on. We write a letter notifying him that. We notify him that when he's done with his leave, we need to meet with him regarding some disciplinary issues. He responds by requesting an extended leave of absence beyond the period of time allowed under FFCRA. We grant it again. The leave then expires. He's scheduled to come back for this meeting regarding disciplinary issues. He does not come back. He doesn't show up on that day. He's then written a letter by my client terminating him for the disciplinary issue. He files a claim for retaliation with the DLSE, and that's where we currently are. So that is a retaliation claim. He alleges retaliation for taking his FFCRA leave. My client's position is no, it is strictly a disciplinary issue. And I'm leaving some things out of there. There's a long history. There's a lot of evidence regarding discipline and blah, 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 blah. But that's the allegation, FCRA retaliation. The other case I have is in Fresno County. It is, the reason this was not on this list, I didn't make this list. This list came from some court-generated website in California. But I suspect the reason this case is not on that list is because the COVID allegations are kind of an underlying allegation. It's a sexual harassment case. And so I represent in that case a supervisor who's alleged to have committed sexual harassment. Co-defendant represents the employer. So the employee in that case alleges sexual harassment, wrongful termination, retaliation. The allegations that are specific, that are relevant for our talk today about COVID are as follows. She alleges sexual harassment. COVID happens. There is a layoff. These allegations are not against my client. These specific allegations are against the co-defendant corporation. There's a layoff related to COVID, lack of business. Plaintiff alleges that her layoff is not in regard to COVID, but her layoff is in regard to her allegations of sexual harassment. So she's alleging retaliation, and she's alleging pretext that the corporation is similar to one of the cases I brought up here a minute ago, that the employer is using COVID as a pretext for her layoff, but her layoff is really related to her allegations of sexual harassment. So we'll see how that plays out. But those are the two cases that I'm aware of. There might be more. I can't believe I'm the only attorney in town that has seen COVID-related cases. All I can tell you is there are none on this list from Kern County. I suspect that my colleagues in town have seen similar cases, but those are the two that I'm aware of. I'm trying to think if I have anything that I've talked about with my clients that are bubbling under. I can't think of any that we've been tipped off that might be filed. I hear things all the time from my clients about, and the things that I hear about are the things that I've already talked about, right? I mean, employees complaining they weren't reimbursed for their Wi-Fi, payment. Employee alleging that they were exposed to COVID at the work site from a subcontractor, and my client might have known about it but didn't notify them in time. Things like that. But nothing that I'm aware of that anybody's actually threatening to file. Although, could show up this afternoon. So those are the things that COVID related I'm aware of right now. Any other questions? No? Okay. So, all right. So moving on the list. The next one in California, Rodriguez versus Allen Distribution. It's a federal case, but filed in California. Again, wages and improper rounding policies. Okay, so the rounding policies wouldn't be specifically related to COVID, but certainly the wages could be. Bottom of page 9, Esco versus Dollar Tree stores. Again, alleging failure to provide proper safety measures in store. So so far, the cases I'm seeing that allege failure to provide proper safety protocols or measures have been in a retail environment and have been in stores. Unsurprising, because you're dealing with the public and you're dealing with customers all day long. But that doesn't mean that another environment where you still deal with the public is not right for such a claim. I can tell you what we've done here at our office. Obviously, we deal with the public on a daily basis. We deal with the public ongoingly on a daily basis, but we have certainly changed how we deal with the public. Those of you that may be familiar with our office, we operate on the 4th floor of a building. So there's no door to our office, right? So if you were to come to the Young Wooldridge building and you get on the elevator on the 1st floor of our building, when you get off the elevator, boom, you're right in our office. So you don't get off the elevator, walk down the hall, open our door. So if you have access to the elevator, you have access to our office. So even, here we are mid-October, we keep our elevator locked. So if someone has an appointment with our office, they have to call from either the 1st floor of the building. The building is now unlocked. But if they have an appointment with me or another attorney in our office, they have to call from downstairs, and then someone has to go down and open the elevator for them and let them up. So, any Joe Schmo off the street can't come up to our office any longer and just pop in. Clients have to be let into the office, and then they're made aware, oh, by the way, when you come up here, we have to take your temperature and you have to put a mask on and et cetera, et cetera. So we have put those protocols into place in addition to the things I mentioned earlier about having a written protocol. And there's anytime we have a meeting in a conference room, as soon as that meeting is over, I know that we're supposed to have that room cleaned down. I suspect that's happening when I don't do it, but I see people after a meeting, I see staff going in there and cleaning it. I know that, again, after I make a copy, I have to clean down the copy machine with a bottle that could be water in it for all I know, but I suspect it's some kind of cleaning solution. So, we put those protocols into place. I know when I go to another law office in town, for instance, I have to go to Klein, Dean, and Talley's office tomorrow for a mediation. I know that I have to be let into their office. I can't just walk in. So I know protocols are being put into place in town, but I'm seeing these cases that I'm seeing allegations of improper protocols and cleaning measures. By and large, they're in retail. I've seen it in Walmart. I've seen it now in Dollar Tree. And I believe the one we saw up earlier was also at, Amazon Fresh. I suspect that's a store. Yeah. So moving on. Page 10. Oh, top of the page. Homeowner versus Amazon.com. An inadequate safety protocol. So that's probably not a store. That's probably, right, like a web office, website, facility. I don't know. Osvatics versus Lyft. That's out of District of Columbia, but that's an FFCRA failure to provide sick leave. So again, now that all employers in California, whether you're greater than 500 or less than 500, you're subject to these expanded sick leave benefits. Make sure you're notifying your employees of their rights to those sick leave benefits and make sure you're providing them, because there are cases being filed for failure to do that. Benson versus Enterprise Holdings, that's a WARN Act. The next case, Talk versus SNL Meat and Produce out of New York, that's a WARN Act case. The next case, Lang versus 24-hour medical staffing. Again, 24-hour medical staffing company. That's a wages and a rest breaks case. So again, I suspect that's a case where you have folks working at an offsite facility or a 24-hour around-the-clock facility, and they're alleging failure to provide adequate rest breaks. McGee versus Postmate, that's a California case, bottom of page 10. Failure to provide PPE. Now, there are a couple of interesting causes of action here that I'm going to talk about before we get away. Where are they at here? Oh, here we go. This was interesting. Top of page 11. This is De La Cruz versus Hometown Buffet. That's California, and the allegation is wrongful termination. I mean, as far as I know, all the hometown buffets had to close. So I don't know any buffet restaurant that's open. So that's going to be interesting to see how you're going to prevail in a wrongful termination case when the restaurant absolutely closed. But I don't know. You never know. Massey versus McDonald's Corporation, improper safety protocols. Again, a restaurant dealing with the public. Another California case near the bottom of page 11, Hartstein versus Hyatt Corporation, a Warren Act case. Middle of page 12, Sires versus Velodyne Lighter, I guess is how you say it. Northern District of California. That's a wrongful termination case alleging layoffs under COVID as a pretext. This is interesting. Near the bottom of page 12, Burr versus Carnival Corporation. I presume that's Carnival Cruises. The entertainers on that cruise line seek full compensation for canceled events. The bottom of page 12, Verhines versus Uber and Rogers versus Lyft. These independent contractors / employees, whatever they're independent contractors who want to be classified as employees, are alleging unpaid sick leave based on misclassification. So that's the end of the case. So you can see the types of cases that are being filed. They run the gamut. Again, half of them essentially allege improper payment of wages. And the other half, you really see most of, they break down to me as either wrongful or improper layoff by not giving warn notices, or you laid me off, you terminated me alleging COVID, but really you terminated me because of something else. You terminated me because I took leave of absence under FFCRA, or you terminated me because I had some sort of protected activity, but you're saying it's because of COVID. So again, like I was saying earlier, same sort of allegations we've always seen, but now there's this layer of COVID added to it. Okay. Now you're saying it's because of COVID, but it's really because of my leave of absence. So again, when you go through terminations or go through layoffs, you got to remember all of your protected categories, all of your protected activities. Now you add COVID to the mix and put that into your checklist. Okay. And if you're going to do a mass layoff, you're going to lay off a third of your workforce or something similar. Remember that you might have to put a warn notice out there and notify your employees ahead of time, and notify the board of supervisors or the city council or whoever is the proper jurisdiction ahead of time. And make sure you're notifying your employees of their expanded rights to benefits under FFCRA, the rights to expanded sick leave. So those are the kind of things that I'm seeing. Okay. Any other questions?
Yes, Jerry. So we have someone who called in, Jane. I'm going to have her ask her question to you right now.
Oh, some real life human contact. Great.
Yes.
Jane, go ahead.
Looks like she has her microphone on mute. Let's see. Ask to unmute. Jane, can you hear us? I don't know when she raised her
Okay.
hand. I just saw it on there, but maybe. Does anyone else have any questions they'd like to ask live? Just raise your hand like the icon or type it in the chat and I'll unmute you.
Jane is indicating she never actually had a question. Well, that's disappointing. I was really excited to deal with the live question.
Does anyone have any comments they want to make? Can type it in the, you can type it in the chat or do like the little hand emoji.
Okay, and as always, if questions arise, please feel free to send me an email or call me. I'm happy to deal with questions as they come up. It's never a problem to respond to a question after the webinar is over.
So someone else just typed a question in the Q&A chat. So they asked, if an employee is out of work because of a COVID symptom, does the employer have to pay them sick leave?
Yes, if they have symptoms that a doctor has indicated are related to COVID, then the employer must provide up to 80 hours of paid sick leave.
All right, any other questions? I typed Jerry's email in the chat, so you, those attending can, if you have a question, like you said, feel free to reach out to him. Thank you again, Jerry. We appreciate you providing these updates for us, especially during such confusing times that we're trying to navigate. Also, thank you to everyone who attended. Again, I'll send, this session was recorded and I'll send the link out. Just see the Q&A again. Another question. Sorry, Jerry. If an employee is out due to COVID and their entire team or department is being laid off, can that employee be laid off as well?
Yeah, I mean, they have no greater protections than if they had not been laid off. So I would talk through that with your attorney to make sure you're doing that properly. But if they were going to be laid off, absent the sick leave, generally the answer would be yes.
And one more question I'm seeing in the chat. And then I also will get to someone else raise their hand. So a couple more questions, Jerry. Is the employee paid sick leave prorated for part-time employees?
Yes.
Okay, and then I'm going to unmute BBB right now to ask a question. Better Business Bureau. They raised their hand. I don't know if they have a question anymore.
Can you hear me?
Yes, we can.
Oh, great. Thank you. We're looking at setting up some protocols. We currently have our office closed, although we do have a few people here that can't work from home. We're looking at, with the flu season coming in, maybe asking people that show a symptom, even that only it be a single one, to go ahead and stay home for a couple of days until that symptom has passed, or to make sure that it's passed. So it'd be an example of somebody that called in sick, that were supposed to be in the office with a headache, which would be one of the symptoms. So we're asking them to stay home an additional day and be able to work from home. Not all of our employees working in the office are currently able to work from home. So I'm concerned about putting in this type of a protocol for existing employees working in an office.
Yeah, so I would be as well. So if employees show symptoms of COVID-19, you're certainly allowed to ask them to stay at home. Do you have sick leave paid sick leave available for these employees, I presume?
Well, we do if they haven't used it all up.
Right,
So
right.
from there, we ask them to use vacation time before they are deducted from pay.
Right, right. Then the question turns to, if you're requiring employees to work from home, you can do that. If an employee doesn't have the ability to work from home, then you get into the issue of whether or not you have to provide equipment, facilities, et cetera, for them to work from home. So there's a lot of issues going on there. You know, when you say an employee doesn't have the ability to work from home, you know, do they have, you know, what's keeping them from doing that? Is it simply a Wi-Fi connection? Do they have a computer but don't have Wi-Fi? Do they not have a computer? You know, what things are there? And might you have to provide those pieces of equipment if you're requiring them to work from home? So there's a lot of considerations involved with that.
Okay, thank you.
Mm-hmm.
You got your live question, Jerry.
Okay. Yes, I did. I was very excited. Yeah.
And then we have 3 more that popped up in
It's been
the
months.
So, okay, so does the employee have to request the sick leave, or the employer automatically grants them?
No, it's not expected that the employee has to request that. I mean, and that goes back to some of these cases we talked about where an employer can be sued for not offering the sick leave. So the employer has to notify the employees of their rights to that sick leave. And what does that mean? Well, it means sending out a policy, right? Drafting a new policy and handing it out to the employees, notifying them that the sick leave is available. And then if an employee notifies HR or the supervisor or whatever, hey, doctor told me I have COVID, or doctor told me that my wife has COVID, I can't come to work or whatever, then the employer has to grant that employee the available paid sick leave. It's not incumbent upon the employee to say, hey, I want that 80 hours of paid sick leave available under the FFCRA. It's the employer's responsibility to provide that sick leave to the employee once they know the employee qualifies for it.
And then these kind of go hand in hand to that. So can an employer require an employee get tested if they are alleging being sick due to COVID-19? And then someone else asked, if an employee is asked to quarantine for 14 days due to possible COVID exposure, does the sick pay apply?
Okay, first question is, can you require them to get tested? No, I don't think you can require them to get tested. I've heard different things about how available tests are. So I don't know. I mean, I can tell you that I got a test because I was going on vacation. So I had the state I was going to required that I provide a test. And so I didn't have much trouble getting a test, and I was able to get my result the same day. So I know that I was able to do that, and my wife was able to do that. But then I've also heard things that say, well, you know, doctors are so backed up now, you can't get tests, blah, 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 blah. So I think what you're able to do at the very least is have notification from a doctor notifying you, the employer, that an employee has symptoms or is not able or should quarantine. Okay. You can suggest an employee get a test. I don't know that you can require an employee to, that's my timer saying my time is up, but we'll keep going. So I'm not aware that you can do that. I think it's dependent upon each county and whether or not how available tests are. Can you repeat the second part of that question for me, Hillary?
If they are asked to quarantine for 14 days due to possible COVID exposure, does the sick pay apply?
Yes. So if an employee is forced to quarantine because they have symptoms or because a family member has COVID, yes, that falls right under the 80 hours of COVID sick leave.
And then another question, if an employee working remotely doesn't want to return back to the office due to not feeling safe, what options does the employer have?
Well, that falls under the reasonable accommodation question. So I think you would treat that like you would any other type of reasonable accommodation issue. I know that courts and the DFEH are going to be very liberal when it comes to trying to accommodate those individuals. So I think at that point, you need to have an interactive process meeting with that employee and see what can you do, if anything, to reasonably accommodate that employee. Can they work remotely? If so, how can that be done? And maybe you can't accommodate them. Okay, I'm not saying you have to do everything possible, but I'm saying you have to try and reasonably accommodate that person. So at that point, I would go through the interactive process with them and see what can be done to reasonably accommodate them.
All right. Well, I think that you've answered all the questions. Thanks for sticking around a couple
Sure.
minutes. And again, thank you, everyone. Thank you to Young Wooldridge for sponsoring our labor law series. This recording, I'll send the link out for those if you want to go back and go through the material. And then again, I'll send out the PowerPoint. But thank you again, Jerry, and I hope that everyone has a great day.
Okay.
Thank you.
Thanks.